Start the recording now. Yeah, please go ahead.
Okay, sure. So then sometime what happens, some of the company, they use only the logo or they use some kind of symbol on their brand. For example, I give you one more example for Nike. So how Nike use brand name or on their product. If you see on the shoes or on t-shirt or garment, they just put right click. Now, when you see the right click, if you are a newcomer, you will be surprised where I can find the Nike brand name. It's hardly they put some anywhere on the product. But slowly, people have identified if it is a right click, it is a Nike. So they don't believe in putting lot of, like images or full name on the product. They want the customer to identify their product by like that only. So under trademark, there are different type of trademark you can do. You can do just word mark. You can do logo mark, which can be with logo, color combination. You can have a word and then logo. And then I told you about series mark, which is one of the example is less. Then there are other company who have a specific packaging and the packaging is very big. For example, of any spices or any garment company, they have a big, carry bag, which they give the customer while selling the product. So what they do the entire packaging as a trademark and they are showcasing their customer ki this is their identity. So a lot of spices and any food product company, they normally want to safeguard their label because as and when their sales getting, more, they get more sale in the market, their visibility increase, lot of other player come as a duplicate product and the best way for them is to copy the same label. So generally, this type of company, they protect not only their brand, they protect the entire packaging where the specific color combination, the font, the style of the label, everything is. So these are the types of trademark I just wanted to highlight in short, because if I go in detail, then it will take more time. Now, how do you do the trademark? What is the procedure? I will just tell you in brief. So like whenever we get any customer, especially pharma company, manufacturing company, is very difficult to find a name which is easily available. So we ask the customer, give us the name. If you have a logo, please share the logo with specific color combination, whatever you are using. And then we search with the trademark office. So we do a thorough search with the trademark data which is available on the website. And based on the search report, we guide our customer whether the brand is conflicting with any other existing brand. In some of the cases, the company is using the brand since last maybe 5 year, 10 year or 15 year. And there are other someone who has filed the trademark, but he has started using since maybe 2 year or 3 year before he filed the trademark. But my client, he is using since last 15 years. So the in trademark, it is the person who is using prior to anyone, he will get a preferential and he need to provide the sales figure. He need to give the user since detail. If suppose he is using say 2008, then he need to say, give us the invoice copy. He need to give us some kind of advertisement or any manufacturing or if he's sourcing from somebody else, then he need to show all this detail to us and we can then get it done. So after search, we prepare the application. We take power of attorney from the customer and then we file the application. Normally it takes minimum 8 months to 1 year, which is the standard time for any trademark to get registered in India. And during the process, we have to communicate with trademark office number of time, right from the after filing the application. If there is any discrepancy, any something is missing out in the application, they call us for to complete the application. Then after that, they examine the application. We normally reply to examination, and uh, everything is now selected by the computer itself. If all the parameter are made and everything as per the norms, then in 60% cases, the application get accepted directly in the trademark office. And if they are not satisfied with your reply, then they call for hearing, and hearing can be attended by only a registered trademark agent or any lawyer. It cannot be attended by anyone just randomly, because they will be asking couple of questions with specific to particular section. There are rejection under section 9, 11, which I can't describe online. But this section 9 and 11 is a very critical section. When there is any similar trademark logo or any such thing, then section 9 and 11 applicable, and it says that the trademark cannot be registered because it's a ground of refusal from trademark office. So after he conducting hearing, we submit affidavit, whatever trademark officer asks, like if they want total sales figure for last 10 year or 15 years since we are using this brand, or any other evidence they think which is required to accept this application. We submit all these, we attend hearing, and then the trademark get accepted. So this is
Mr. Sandeep, are you sharing any PPT?
no, I mean,
Okay,
see,
fine,
PPT
fine.
I can share, but
No,
I
no.
would like to be raw. I would like to say what is there in my mind,
Yes.
and then because PPT we sometimes we get lost and we just concentrate on what is there on the screen.
Absolutely. Please go ahead.
Yeah, so somebody has asked, Shetal has asked, if word mark is registered in black and white and approved, cannot be used in any color. So what happened, I am coming back to that because under copyright, if you have a logo, and if that logo, you put it in black and white and you put before the trademark office and copyright office, then if you put it in black and white, you can use any color. It doesn't matter. Your style and font should remain same. And if anybody copy with any other different color, you can easily stop them. So it's always advisable to file in black and white so that you can use all the color. I hope, Chital, you are satisfied with this. So do you have any other question in respect of trademark? Because I just, given a brief and short, detail about trademark registration.
So Sheetal here again. So same applies for logo also, is it? Or it applies
Yes,
only
yes.
for word mark?
No, it's applied for the logo as well, because a lot of company use a logo on their product and packaging. So what happened when you file as a black and white, you can use any color, because if you are into garment, for example, you have a blue t-shirt, so you can't put red color logo on that or blue color logo on that, because otherwise it will not be visible.
Right.
So that is why always lawyer advise to file in black and white so that they can use any other color, whatever they think is right.
Okay, thank you.
Any other question for trademark? So then I can move to copyright, because under trademark, then I will I will brief about the comparison between trademark, copyright, and
Yeah, I have a question.
yes, Sagar.
So, I was doing one trademark valuation. So, in that, the company gave me the list of the trademarks, and then there was a couple of the categories in the trademark, like applied, abandoned, pending for registration, unregistered, and then still they are selling it, and abandoned, then still they are or opposed. So, what are these kind of the categories?
Yes, yes, good question, Sagar. I forgot to mention. So under trademark, there are total 1 to 45 classes. There are total 45 classes. So
Okay.
class 1 to 34 is for product, for manufacturing or trading. Class 35 to 45 is for service industry. So suppose you are running a university, your college, training institute, so then class 42 is applicable. If you are running a restaurant, hotel, then class 43 is applicable. So different business, different classes apply. Class 1 is for chemical and all. Likewise, there are different classes for different product. For pharmaceutical, it's for class 5. For jewelry business, the class 14 is applicable. For leather bags and all, class 18 is applicable. For garment, class 25 is applicable. For any online shopping or online service, class 35. For example, Amazon, Swiggy, Zomato. So these all fall under class 35 because they are selling through e-commerce platform. So different classes applicable for different businesses. Now coming back to your question, when you are checking valuation, you find different status for the application. So when you file the application, it just say application, new application. Then after new application, if your application is verified by trademark and everything is as per the norms which they want, then they put formality check pass. Formality check pass means application is verified, there is no discrepancy in the application, and it is good to go. Then after formality check pass, they put examination report issued. So when they examine the application, whatever query, objection, which is coming after the going through the application, and then they check the record. If there is any similar trademark, logo, or any conflicting mark is there in the system. So based on that, we reply and we submit our reply to trademark office. If they are satisfied, then they directly put it accepted and advertise. If they are not happy with the reply, they call for hearing. So then it shows like it's marked for hearing. The file is called for hearing, and then in next 3 to 6 months, automatically they schedule a hearing. But if they accept before hearing, then marks directly get accepted and it get advertised in trademark journal. Now trademark journal can be seen by any lawyer or any advocate across the world. They can just go on the trademark website, they can open the journal which is getting published every week. Any application whichever gets accepted by trademark office, they publish in the trademark journal, so that anybody who has an objection or they think it is similar to their application or resembling to their brand, they can file a opposition through trademark office. So then the file get accepted and it get advertised in the trademark journal. Within first 4 months of this journal period, if you make an opposition, then the trademark registration get on hold, and both the party then file all the evidence under rule 45 and 46 to submit their case. So suppose if I am opposing someone on certain ground where that this brand resembling with my client brand, then I submit all the evidence, and that evidence is checked by the trademark office, and then they call for final hearing. Now in some cases, what happened, whatever I told you so far, we reply to examination report and we communicate with trademark office even after certain objection or after the file is getting advertised in the trademark journal. But in some cases, some agent, they file application, they don't know the process, they don't reply anything to the trademark office. So the file get abandoned, or trademark offices ask for certain evidence under rule 45, 46. They don't submit those evidence to the trademark office within that time. So in such cases, the trademark get abandoned or withdrawn, So then that particular file is closed. You cannot use the trademark afterwards if it is rejected by trademark office. But sometimes people just because of uh, it's not very commonly known in the market, so they try to use that particular brand goodwill and they continue selling in the market with the same brand name. So ideally, any abandoned or any withdrawn brand have no value in on paper, especially when you are talking about valuation. Sagar, I think you are
Sandeep,
happy with my reply, or you have any
considering the
other?
context, considering the time constraint, I request you to continue with valuation
Yeah.
because the forum and the audience is more keen to know about the valuation and it is very complicated and tricky.
Correct, correct. No, I know, but see, once they understand, then valuation won't take more than 15 minutes. That is the last what I say, because I have done similar for Mumbai Valuation Association, and we did it in the same format, because for them to understand how the process, how it create a value, and then I will unlock at the last how it will impact the valuation of the business. I will quickly cover, don't worry, miss.
Yeah, sir. So that was a very nice explanation. So I just want to last confirm that
Hmm.
how would we get to know that, okay, now this trademark is final,
Hmm.
approved, and now it is owned by the client, and there is no opposition, no further claim to be done by any party.
So, Sagar, what happened when the mark get registered? No, there
Hmm,
is no further question or hearing. Then it shows it registered. Any
registered.
application, yes. And the
Okay.
client will provide you registration certificate, which is issued by trademark office, which will have a validity of 10 years, and it will show on the trademark certificate also. Ki from this day till this day, it will be registered. And then after 10 years, you have to renew. Suppose you have filed in 2012. So 2022, you have to renew. If you have not done the renewal, then again the trademark is not valid.
Okay. Thank you. Thank you, sir.
Welcome. Now Sheetal is asking, under which class trademark of a retailer will be filed if he deals in all kind of general store or stationery product. So when you are manufacturing or trading of this product, so you have to file for stationery class 16, and for other general store like food and packaging other stuff, it fall from class 29, 30, 31 and 32. So depend on your product, the class will be applicable. But if you are doing through retail like supermarket or through e-commerce, then class 35, because you are not only manufacturing, you are supplying to the customer through this chain. Okay, Shita?
So also, sir, if we are valuing this particular retail store,
Hmm.
then in that case, should we take into consideration whether under all these classes which are eligible for him, whether they have a approved or registered trademark for such
Of course,
kind of classes or not?
of course. For example, Big Bazaar sell atta also,
Right.
cloth also. So under ready-made garment also they have registered class 25. So basically, when a typical company who have a multiple businesses or multiple platform to sell their product, they register in all the classes. For example, Reliance now, they were not into retail, but if you see in last 6-7 years, they are expanding big way in all the sector. They are not restricted to only telecom or oil and gas. They are expanding in all the business.
But they are not the manufacturers like Big Bazaar. When we say it, they are retailers only. Manufacturers are somebody else from whom they buy and then resell it.
So for
And they have
example,
only one.
yeah, for example, when you buy atta from a floor, any mill, floor mill,
Huh.
you put it in the bag and you put your brand. So then you
Right.
become a manufacturer, no? Because you can do third party manufacturing. You can have an agreement with any vendor who will especially manufacture for you, and then you are putting your own label and packaging. So then it will be called, like, you have to file in a ATA category, which is class 30, and then you are selling through your supermarket. So you should have a registration under class 35 as well.
Like if they want to go ahead with multiple classes, they can rather go with class 99, I think so, right?
Yeah, class 99 is like you can file one single application under which all the classes will be covered. It's like not filing 45 application, filing
Right.
one single application and covering all the classes.
And they get this approval or registered trademark under class 99 itself?
Yeah, because again, it will examine in all the classes. And if there is any objection in any class, then your certificate is on hold till the process is completed.
Okay.
So it's not like this is just one convenient for any advocate to file one single application for all the classes. But we always advise file separately. So suppose your trademark is suppose under class 11 or 14. Rest of the classes is accepted. So you start getting certificate for other classes. Only for these two classes, your procedure is in process with the trademark office. And as and when the hearing is over, all the submission is done, you will finally get the certificate.
But there is a possibility that we can get for other classes, we can get the registered trademark.
Yes,
But
you can
for
get.
some classes, it will be on hold.
Yes, of course. This is the process generally.
Okay,
And
I was
one
under
thing-
assumption, I thought that if one or two classes also it's on hold, then the complete, all the classes will be on hold. It's not that way.
No, not that way. It is class-wise, ma'am.
Okay, sir. Okay. Thank you.
Yeah, welcome. Vandana has asked abandoned trademark can be registered again. Yeah, of course. If any trademark is abandoned because of any negligence or some of the document which is not submitted or the procedure has not been followed, then we can again refile and then we can get it registered.
Thank you.
Yeah.
Sir, I have a question.
Yeah, one. Who's this?
Sir, I'm Vaibhav Gupta.
Yeah, Vaibhav, please, go ahead.
So, sir, I have a question. So, for example, Big Bazaar is there,
Mhm,
and it is a reseller of all the products.
mhm.
So, does it have to register trademark in under all the categories?
No, depend, Vaibhav. See, sometime what happened, like they are selling right now multiple things, but they are not selling like electronics, for example. So they are selling only LG, Volta, Sony. So this product, they can't have their own name on the product. But any product which can be sourced from third party and they can put their own label and packaging, they can cover those classes. The great example is any food item, any stationery item, or garments, bags. So these are the general classes which they can put their own brand name.
Okay, right. And you mentioned about an ancillary class wherein
Mhm.
we get registration in all the classes. What was that class number?
Class 99, which I think Sheetal was saying about it.
So
Sheetal
class
was-
9, class
Class
99.
99 is for one
if I
single
file
application for all the classes.
right. So if I file an application in class 99 and existing trademark is there which has a similar color combination or any opposing in class 1, so
Hmm.
my registration will not get through, right?
Yeah, it will not go through till you resolve all the query or objection from trademark office or any third party.
Of any of
Sometimes,
the classes, right?
yes. So for example, I give you like one of the example recently, one of the client has filed the trademark A1 Gold. It is from Bangalore only. They are into steel. They have multiple plants in Karnataka. So A1 cycle as A1 cycle you must be knowing from Ludhiana. They have filed opposition when the mark got advertised in the trademark journal. And the matter was pending for almost 8 to 9 years. And multiple lawyer has attended hearing, but nobody could resolve the matter. Finally, the matter came to us last year, and last month only we got the order in favor of A1 Gold, which is a very big brand in Bangalore. So you have to sometime follow the rules as per trademark office. You have to file all the necessary evidence, document, you have to argue, you have to satisfy the officer that this brand can be registered and it is not resembling with other existing brand. So I will quickly move now. Shirley Matthew has asked, can opposed trademark be sold? Of course, opposition can be done by anyone. Suppose if I'm your competitor and your mark is not resembling or identical with my brand, then too I file opposition just to stop you for the registration. So the mark is opposed and sometimes it takes 3 years, 5 years to get it registered after opposition. Because n number of cases, like in High Court, there are n number of cases going on since last 10 years, 15 years. Likewise, same in trademark office, because a lot of application is filed on daily basis. So opposed trademark does not mean the mark cannot be registered, but it depends on case to case. So of course, opposed trademark can be sold.
Thank you, sir.
So now I would like to move to copyright, because we have already 40 minutes is over, and as Shilpa said, we have to quickly before we focus on valuation part. So just one more thing, whenever you file any trademark in India, it is a geographical rights. When you file in India, you can use only in India. It does not mean you directly sell to any other country while sitting in India. For example, you sell some product and then you are directly exporting to UAE, Singapore, or any other country. So then you have to file application in that respective country as well. Otherwise, anybody can sue from that country for loss of goodwill, loss of profit and compensation. And the trademark is valid for 10 years. The day you file, it will be valid for next 10 years. After every 10 years, you have to renew. If you don't renew, then you again lose the trademark. So I hope that is very clear with all the audience today. Any other question you can ask me, then I am moving to copyright. So under copyright, there are different type of registration. One is of course logo.
Sir, I have just one question, sir. Sir, you were talking about a situation where goods, if they're sold in different countries, you need to apply for trademark in those respective countries, and it's valid for 10 years. What
Correct.
about service mark? If I'm actually rendering services, the recipient of service will be worldwide, but I'm actually sitting in India and rendering services. In such cases, how does that work?
So it depends. Suppose if I am giving education related or lecture or tuition or any kind of other teaching material. So my place of business is India only. I am not personally going there, correct? So then in that case, it is not applicable. But if I am selling any product which is crossing the border and it is going through courier or through other platform like shipping or by cargo, then it is going to the custom of that particular country. When it reaches the custom normally asks, do you have a trademark certificate? Do you own this brand? And then if you provide the document, so there will be no problem. But if you don't have a document, then anyone from that particular country can sue you. They can ask for loss of goodwill, loss of profit. So it is a geographical rights. You are
What we can conclude is any product that is sold incidental to the service, those things needs to be, there should be a trademark on those goods sold. Otherwise, if it is only a service mark where everything is virtual, then there is no requirement to seek a registration in a different geographical location.
Of course, because suppose now we are having webinar. Now if anybody joined from Sri Lanka, US or any other country, how do I control? I am doing in India and it is open for all audience. They can be anywhere in the world. But if I am doing specifically for US and I am only inviting US valuation expert, then there can be a problem and then he can issue a notice to me. Because this particular what you are using on this platform is belong to me. So you have to take my prior approval or authorization.
Got it, sir. Thank you so much for this clarification. And sir, one last thing is you were talking about all any trademark is valid for 10 years. What about
Right.
service mark? Even the validity of a service mark is 10 years only?
Yes, yes. Any trademark
And
is for product or service, the validity is 10 years.
and after the validity is over or prior to the expiry of the validity, it has to be renewed.
Yes, you can renew 1 year in advance, and again you can renew for 10 years, and it can be for lifelong. Like every 10 years you can renew.
Okay, but it is important that what happens if one forgets to renew or one assumes that it is actually valid for a lifetime?
So suppose if somebody forget, then anybody else can apply and they can get it registered. Then the trademark lapse after 10 years, they give another 6 months with late fees. If you apply within that 6 months to 1 year, then you can again get the registration certificate renewed for 10 years. If you don't do after even 1 year, then you cannot renew the trademark and the trademark lapse on that.
Okay, so just to get a little more understanding. So assume that I have not renewed and a similar logo actually is submitted to the trademark to the registrar of trademark. So will it become the responsibility of the registrar of trademarks to intimate the prior trademark holder that this is being registered? I know. Do you have any objection?
Yeah. So like we have a system in our office where we have put all our client trademark and we directly automatically get notification on our email and on our system that these particular trademarks are due for renewal in next 1 year. And then we send the email and WhatsApp or through telephone call, we intimate them that they need to renew. And if they renew, then again they can use for next 10 years. If they don't renew, then the trademark automatically get cancelled and then it is open for all the general public who or anybody wants to apply.
Sure, sir. Thanks so much for this clarification.
You are most welcome, Kusum. So one more, how does trademark office check for internationally recognized trademark? So every country have their own website. If you file for US, there is US trademark and patent office. Likewise, you go to any other country, they have their own data and you have to hire a professional person, trademark agent who can do the proper search. And if it is available, then you can file. While sitting in India, you cannot check for all this country. Every country have a different system. Some of the countries still are offline. They are not online, especially typical South African companies, countries, small country where there is no proper internet or infrastructure.
The question was more on if a trademark is recognized outside India and somebody is filing for recognizing it in India, can the owner of the trademark outside India object to that I have a trademark similar name recognized somewhere in Singapore or USA or something, and therefore the Indian fellows will are bound not to recognize it because it is recognized somewhere outside India?
Correct. So like a trademark, some of the trademark is well known. For example, like Apple, Microsoft. So these are known worldwide. So if they have not filed in one particular country and you try and go and file there, the application directly get rejected because it is already accepted worldwide. But some of the brand which is only there in one or two country, but they are not selling anywhere in the world. And then you think, okay, this brand, I can create a buzz in the market and I can use in my country and I will have a ownership on this brand. Then of course you can file. There is no compulsion. It depends on business size. If the business is substantial, it's at a very good level, then you can go to that particular country and you can say this brand is already registered here and I could not file in your country as I don't have a, you can then stop and oppose some other opponent. But in most of the cases, the brand is recognized and they don't accept in that particular country. But if it is at a very small level, then definitely you can register and you can use it. I hope it's very clear, right? Am I audible?
Yes, sir, you're audible.
Okay, because there was some fluctuation, so I thought, okay, so I'm now moving to copyright, and under copyright there are different type of copyright. One is, I have already mentioned about logo copyright, but there are different type of copyright which any company can register, and it can definitely create a lot of valuation for their business. For example, uh, uh, you have any software, so that software programming can be copyrighted. Then any lyrics, any song. Now you have written a song, so that lyrics you can do copyright. Then when you sing that song can be copyrighted. If you put a music with that song, then again it can be copyrighted in different form. Likewise, any specific photo you have with someone, or which is not available in public domain, you want to have an exclusive right. You have met president of any country or India, you have got certain award, and you don't want any media to use that photograph, so you copyright, and then all these newspaper or media have to take a right from you in writing. For example, any celebrity, when they get married, they click photograph, they have certain video, so that cannot be used by anyone. They do copyright for all these things, and then they give it on royalty basis. So any kind of painting, video, photographs, any software program, logo, this can be copyrighted. There are different type of copyright, and different forms and fees are applicable for this.
Sir, I have a question. Sanjay here.
Yes, sir.
Sanjay Gupta. This NFTs are there, correct?
Mhm.
So they kind of give you a right over any intellectual property. Now, will they replace the patent and trademarks law very shortly? What do you think? What is your view? And how are they related today? If I have an NFT, and of course it's recognized worldwide, but
Correct.
it's not there in India. In relation to that, if somebody comes to me with a valuation for that, how do I handle such situations?
So you have rightly you have selected the, I mean, very tricky thing. It's not, it's not accepted in India, because India have a different law.
Yeah.
Uh, there are many things which can be registrable in US, but if you file in India, it will not get registered. The simple reason is NFT is still not very well recognized in India, and there is uh, a lot of manipulation and speculation is going on in NFT, and especially in Bitcoins. So any character which they are using, they have taken the approval from the parent company for the images and all. And those images, based on their agreement, they are using. So any company who use this sort of images with the NFT, they have to take approval from that particular parent company in writing, and they are paying certain royalty to them.
So, but I mean, in India, if there's a violation of NFT, then you can't be held responsible, you're saying, is it?
No, yeah. Because now the government is very serious, and they are now making certain rules and regulation. But as of now, there is no such rules here in India. And
Okay, so it has to evolve.
Also, if you buy any international NFT or Bitcoin, you have to not make payment through your Indian card. You have to disclose to RBI. You will get a letter from RBI even if you make the payment. And they are checking both your credit card and bank statement. They are closely monitoring all this.
No, so it's not a capital account transaction, correct? It's a revenue transaction. So, I mean, if you buy it, there's no issue.
So ultimately,
It's like any other purchases. It's like any other
it's like
purchases.
a financial transaction only, no?
Yeah. So it's
Before going-
under my LRS, I can always buy. Correct. There's no issue.
Yes, you
Yes,
can.
under my LRS, I can buy. Yeah.
Correct.
Okay. Okay.
Yeah. Chirag,
Thank
you
you.
wanted to ask something?
Am I audible?
Yeah.
Sir, whether this NFTs can be manipulated or the rights for NFTs can be infringed? I think so that this is exclusive rights and it cannot be infringed at all.
No, yeah, of course, because see, they have everything in writing. They make a proper agreement, and then based on that, they are using this NFT. So your rights are secured. You can sue them.
Okay.
Any other question? Because we are running out of time. It's already 8:30. I have to cover patent, and I will tell you lastly why these registration are important. Anybody wanted to ask any question?
As you said, the trademark attorney can file the application or represent. How about copyright?
Same, ma'am. We have to file power of attorney along with our application. And whenever there is any discrepancy, any thing, then it is attended by the agent only. It cannot.
Is he trademark agent or copyright agent separate will be there?
No, same. The trademark agent itself file the copyright application. There are two type of agent. One is for trademark and copyright, and one is for patent, because it requires different skill and drafting for this kind of work.
Okay.
Because copyright have a standard format, and once you file this application, the format remains same. It's just that sometimes you are filing for lyrics, sometimes you are filing for painting, sometimes you are doing for software. So hardly there is any 15-20% difference in this type of application. Overall, the application format and procedure remains same.
So what is the quintessential difference between trademark and copyrights?
So the trademark is your brand, your identity. You sell your business through certain brand name with have a certain logo or tagline. So that is your trademark. Copyright can be your any. For example, if you are selling your business through content, you have a website. So whatever you are putting on the website, that is your bread and butter of business. So this content you do copyright, and then if anybody use those content, you can sue them and you can ask for compensation. Likewise, you create any painting, you write certain books or novel, you create a certain song, music. So this you register under copyright, and then you sell in the market. So there are like MF Hussain painting. You know how crazy is the amount for one painting. Anybody can copy MF Hussain painting, but he register all of them. He put his signature, and anybody who tried to copy, he need to pay compensation to him. So these are the two basic difference.
Thank you, sir. And also patents are, my understanding is it is, like if it is a software codes are developed, then they get patented, correct?
Yes, I will come back.
Is that not a copyright?
Yeah, see, in India, generally the software program is not recognized under patent. So normally we file under copyright, because whatever programming, coding, or some secret, content, which is very essential for the product, they do copyright so that in case somebody misuse, they can take legal action. I will, when I start about patent, I will tell you how US companies are filing patent for software programming and, problem solving issue. We will cover that in another 5 minutes.
Thank you.
Yeah. So,
Sir, I have a question.
yeah.
Sir, in case somebody writes up an article or a book and gets it copyrighted, right?
Mhm.
and I, as a presenter or an author, I take some certain extracts out of those contents, out of say for example your presentation, which you have given today,
Mhm.
and take and publish it in a public domain
Okay.
with giving due credits.
No, but
That
then too, if you are going in the public and you are putting on a certain platform, whether it's online or any newspaper or magazine,
Hmm.
take prior approval in writing.
Okay.
If I am the owner and I have not
Mhm.
told you to publish, you have no
Mhm.
right to publish my thing unless and until I give you in writing or we have some sort of agreement or understanding.
Okay. Okay. Okay.
Just
So
like
if I,
for example, I give you example of for Shreya Ghosal. She is a very famous singer. She is
Mhm.
signed. So she has certain photograph which she has registered under copyright. She
Okay.
was President of India, Prime Minister of India. Certain
Mhm.
awards she got where certain dignitary they reach their home and
Mhm.
given award to her. So
Mhm.
those particular images she has not allowed any media house or channel to publish on a public domain. If they want,
Okay.
they can take permission, they can pay royalty and then they can use it on their platform. You can visit her
Okay.
website and you can see she has already mentioned that these are content and images are copyrighted. You cannot use it.
Okay. Okay. Right, sir. Right.
Any other question or should? So, see, under copyright, for example, I told you like it is for lifelong. You don't have to renew your
Sir, I
copyright.
had one question, sir. Before you,
Yeah,
hello, sorry,
just
sir.
Sanjay,
I had one question. Yeah,
Sanjay, just one
Sanjay
minute.
here.
Yeah.
Yeah,
So
Sanjay, Sanjay.
under copyright, what happened when you file for registration? No, so your validity is for 60 year, 60 for 60 year. So you don't have to renew. Once you file the copyright, you get registration, and then you can continue using it. You must have seen on the news channel, lot of website they put copyright rights reserved. Then at the rate 2023, 2022, they you just put the year which is running. Why? Because they know they have filed the copyright, they got registration, and it is valid for next 60 years. Correct. Now, Sanjay, please go ahead. Sorry.
Yeah. So what I was saying, the similar to this point, what you're explaining, is that when we are doing things, correct, we may accidentally violate copyrights, and we don't know. So how do we check whether a copyright is getting violated or not violated when we are using any word, trademarks, etc. process? I mean, it's so complex. So I mean, as professionals, how do we ensure, or as auditors, how do we ensure that the client has not violated the copyrights? It's
Very
only when somebody files, then you come to know that you're violated. Is there any proactive way that we can do things or know things? I'm talking about is there an industry practice or something like that?
Oh, Sanjay, it's a very good question. And
Mhm.
country like India and China,
Hmm.
so it's very common. People use same brand in different state and at a very remote place also. Like for example, in one particular state, for example, Bihar, there is
Mhm.
a district and there is one village.
Hmm.
People are using that brand which is registered in Bombay or Delhi. Now,
Mhm.
now the guy who's selling in Mumbai and Delhi, he don't mind somebody using in a very remote place because
Mhm.
he is not his audience and customer.
Yeah, he's not impacted. Correct. You're right.
And whenever you want to take any action or you create like investigation in the
Mhm.
market, so your market is mostly restricted to metro and 2 tier and 3 tier city. You never go to village and identify who's using this brand. So country
Correct.
like India and China, it's a very common that people are using resembling brand or similar brand, but unless and until it impact your business, nobody cares actually. And
Mhm.
as a trademark agent, we have seen n number of trademark copied in remote place. And when we tell our client, their first reply is, "We don't bother. They are not our audience, and it hardly matter to us." Even if we try to stop them, they will stop for some time, and then again after 1 month they will restart.
Correct.
So, and it is a very costly procedure. You go through either high court, you take injunction, or you go to the local police station, you file a complaint. So you have to spend a lot of time, money, and then stop this. So unless it directly impact your business, nobody cares at a very initial level or a small level.
So basically, it's a toothless thing, correct? I mean, if you're not impacted or you yeah, okay.
So, like some of our client, what they have seen, like they have registered certain design under. I will cover under patent. So, suppose you have a product, for example, this glass. So now this glass is a different shape. Okay. Now this product is become a famous in India. Okay. Now somebody is importing from China, and certain manufacturer is manufacturing this. You go to China, you give this glass and you say, I want same configuration and same color. You will get a same type of glass. You bring it to India and you sell. So in China, there is no IP protection, even if you have a registration, because they have one policy. They want just business and they want to export. These are the only true criteria they follow. But in India, if you have a registration, you are selling and you have all the rights, you can stop anyone, even if he is selling at a remote place. But it will have certain costs and certain time period.
Thank you. Right, understand this.
So I got one more. Can a logo be also registered under copyright? Yes. So like every logo have a color combination. Now when you file a trademark, you get a right on name. Okay. The color combination cannot be secured under trademark. Trademark gives right only on the name. If you want to claim your specific color combination, font, size, then you have to file copyright. And that copyright, if you file in black and white color, then you can use all the color. If you don't file in black and white, you file in a specific color, then you can use only that particular color.
So, sir, in that case, the validity of such logo or a trademark will be for 60 years or 10 years.
If you are filing for trademark, 10 year, but if you are filing for copyright, it is 60 year.
And if we are filing for both, then the value will increase?
No, yeah, value will increase, of course, because you have a trademark, you have a copyright. Why you file copyright? Because copyright is a criminal offense under section 60, 63 and 59. If someone misuse your brand with logo, you can file a criminal complaint. It is a non-bailable offense. The person will be behind the bar for at least 1 week till he gets any sort of bail.
And sir, if such kind of copyright is being infringed, then in that case, I'm sorry, the procedure of approval under copyright is early or under trademark is early?
So see, both the registration have a similar process, but we have found with our experience that copyright can be obtained quickly rather than trademark. Trademark sometimes take 1 year, 2 year, or if any opposition come, it sometimes take 5 year or 10 year also in typical cases. Whereas in case of copyright, the registration can be done in 6 months, 8 months, or at the most 1.5 year. So copyright is little faster than trademark.
Right. Thank you, sir. Thank you.
Any other question with respect to trademark, copyright, anything which is not you are not able to understand or still bothering you?
So one more question: is this registration process centralized or it is decentralized? So you have a state-wise thing, or
No,
is it
centralized. It comes under Commerce Ministry.
Okay.
And there is a department which cover intellectual property right registration. So under trademark, the trademark head office is in Mumbai. It is under central government. Copyright head office is in Mumbai. Sorry, Delhi. And for design and patent, the head office in Calcutta.
Okay, so 3 places we've got these offices. Got it.
And
Got it.
total, there are 5 offices for patent and trademark. You have a Bombay, Delhi, Chennai, Kolkata, and Ahmedabad.
Okay. Okay.
So
Okay.
for North India, Delhi is the appropriate office. For West India, Mumbai is the office. For
Mhm.
East, Kolkata. For South, Chennai. And for Rajasthan and Gujarat, Ahmedabad.
So, I mean, these are all different types of registration that they do. Correct. So, for if I got something, everyone will have to go to Delhi. Correct. They can't go to Calcutta or these other 2 offices.
No, if your registered office in Delhi, you have to file through Delhi office, and you can file online. You don't need to go physically there. Everything
Okay.
is
Everything is online. Okay.
yeah,
Got
because like
this.
we are filing in all these 5 registry.
Okay. Okay.
In Calcutta, we don't have an office now because after COVID we closed because we were
Mhm.
not getting any physical meeting. Everything is online. So
Mhm.
I have an office. If I need, then I can send my advocate on that particular day.
Right. Got this. Thank you.
I got one more question. Validity of copyright is lifetime of author plus 60 year. No, it is for 60 year, not lifetime. If you after 60 year, automatically your registration get cancelled. You cannot renew and you cannot use. You have to file fresh application. Any other question or should I move? So now I'm coming to the most important topic is design and patent registration. So under patent, there are 2 type of registration. One is design and one is innovative or product patent. For example, I have given an example of this glass. So this glass shape configuration, you can register under design registration because every manufacturing company have a different product and they have a different shape configuration. So they want to safeguard this so that their competitor cannot use the same product. So they register this design under design registration, which comes under patent. And this design registration is valid for 20 years. Now across the globe, they are giving this registration for 10 years, and then you can renew for another 5 years. And after 20 years, you cannot renew. The reason is the technology is changing, the product overall use is changing. Now you use this glass, after 5 years, you will not like this glass. You want certain different design or color. So that is why the registration validity is only for 20 years. That is lifetime validity of the product registration. So under design registration, any product shape, configuration, the way you are manufacturing or selling this product can be designed, can be protected under design registration. Now, when it comes to patent process or product, if your product is unique, for example, if you compare your product with any existing product which is available in the market and you are offering something new which is not done by anyone before that, then you can file under patent, which will cover your new product development registration or process. For example, there are multiple uh, food item or chemicals or pharmaceutical product. So what they do, they are making this product through certain process, which is very I mean, it is very costly or it takes lot of time in manufacturing this particular medicine or chemical. Now you have certain process which will reduce the time, it will reduce the cost, and it will give you more value. Then you can file a product patent for the process, or if it is not process or if it is a product which is giving you better output or better advantage compared to the current product, then you can cover under patent product. Now difference between a design and process and patent product is design can be filed by many companies in India. They just want to safeguard the design so that they don't have a competition. Plus, in case of any litigation, they can safeguard their interest. But any patented process or product, if you got a patent registration from patent office, then you can highlight on your product that this particular process or product is patented, and if anybody misuse, you can sue them, you can call for loss of profit. Plus, that product can be sold by your company only. No one else can sell this product. Especially in pharmaceutical, you must have seen all the big pharma company, they have a patent and they have a monopoly in the market, and they only manufacture and they export to various countries because they got the patent on that. If any other company want to sell those products, they make an agreement with the manufacturer, they pay royalty, and then they sell to their customer. They cannot sell it without proper agreement or rights. And patent is again valid for 20 years, and this is not renewable because the product and technology is changing very fast. The latest example is iPhone. If you have seen in last 7 years, multiple new iPhone came, and every iPhone have a different features, or like camera, they have a better visibility. You can, earlier we could not do FaceTime. Now they have a FaceTime. You can use your email, you can use all social media, you can send file from one iPhone to other iPhone. So any added feature they add in the new phone, they file for patent, and then they make sure nobody else can use that technology. So they have a monopoly and they can sell at a bigger price. Whenever they come up with new phone, they sell at a very high price because they are launching, and they would know the customer want to use this technology. So they sell at a higher price, and when the new iPhone comes, for example, iPhone 13 came, now iPhone 14 is coming. So automatically iPhone 13 price goes down because people are buying iPhone 14. Nobody buy then iPhone 11, 12 or 13. And their manufacturing cost also reduces because they have already made a lot of money, and the more they manufacture, their costing goes down. So in patent, it all depend on what set of business you are running, and whether it is a process driven product or it is an innovative product. So depend on the process or product, we suggest the client to file patent. Any question or anything which you could not understand?
So what is process driven product?
So for example, you have certain recipe and you are making a food at home. So the standard process is same. You take all the ingredients, you start the process, and you make a dish. But through this innovative process, you are making the same product, but in a lesser time, or it is reducing the cost of the product, or the process itself is changed. How you are making the product is completely changed. So you can file a patent for that, and you can claim exclusive rights on that particular process.
Got it.
Like for pharmaceutical, some of the medicine, it takes like certain period of time before they can manufacture and sell to the patient or hospital. Now, because the technology is coming, they are trying different innovative way to manufacture it faster. For example, during COVID, so a lot of pharma company were developing COVID vaccine. Okay, and they tried a lot of different process and chemical to create a vaccine. So any new vaccine which is giving you better result, it was patented. It was they filed number of patent. And finally, when they got a better result, they officially launch in the market. They do trial, and once they are satisfied with the trial, they launch in the market and they highlight this is a patented product. Anybody who use this product without our permission or manufacture, they can claim loss of profit and loss of goodwill from that particular company.
For clinical trials, are there any IPRs?
Of course, all the company who have a research and development within their company, they file multiple patent for one product, and after filing maybe 5, 10 or 15 patent, they freeze one out of that. This is what we are going in the market and we are going to sell this product. They don't sell all the 15 products, but to safeguard their interest till the clinical trial is going on or they are not satisfied with the final outcome, they file multiple patent for the same product. For example, Tata Nano. Tata Nano was the cheapest car in the world. They filed 700 patent for one this Tata Nano car. Every feature has a patent.
Okay.
So we like we
Sandeep
filed.
ji, Sandeep ji, one question here, Sanjay. Yeah. What is the typical cost of filing a patent and going through that? You said it takes 2 to 3 years, correct? For
Yeah,
patent
so
to get
there
done.
are
So hearings and on an average, I'm saying, yeah, they will be case to case, but on an average, how much cost it takes to get one patent done or one
again
copyright done?
costing is a tricky thing because there are certain parameter for costing. One is whether you are filing as an individual or company. For
Company typically, yeah. typically company.
the fees is high. है ना? And then if you are a startup or MSME or SME company, so then you get a discount from the government. They reduce 50% of the government fees. Because you are a startup, you are falling under MSME and SME. For big corporate, there is no discount because they can afford this cost.
Okay. So it ranges, let's say 50,000, a lakh, 5 lakh, how much
Yeah.
should budget, one budget?
So for ideally for individual, we are charging close to 1 lakh rupees. This cover your global search because whenever we want to file a patent, we have to search globally. The same patent is not filed by anyone across the world. If it is already filed, you cannot claim the patent on that particular.
Okay. So global search has to be done, and then only we can know whether we can file in India or not.
Correct.
Okay.
And this search is performed by the patent agent who are well equipped with the knowledge. They have the degree with them, and they go to various sites which is created by the government of that particular country. So, for example, we go to US Patent Office, we go to website of European Patent Office, Japanese Patent Office, UAE Patent Office, Indian Patent Office, and we search the keywords on this site, and we search all the database, and then prepare a report which we share to the our client. These are the patent we have found, and these are resembling with your invention or product, and then do technical discussion with them before we conclude how we are going ahead and how we are going to file the application.
Okay.
And for company, it costs around 1.4, 1.5 lakh, roughly in India.
In India.
If you go internationally, then every country have a different fees. Roughly, it goes from 1 lakh to 8 lakhs or 10 lakh rupees. So like US is the most costliest one because it takes a lot of time and effort, and their attorney charges very high fees. They charge on hourly basis. So suppose for a patent, it requires 20 hours for one patent, and they charge like $300, $400 per hour. So then it will multiply into 20 hours. So it will cost you $8,000 just for his consultancy.
Okay. Got this.
So now somebody has asked eligibility and qualification. Anyone who has a legal background, if you have done LLB, you have done BCom, you can appear for a IP exam, whether it is for trademark and patent. And after giving exam, if you are pass, you can become an agent. And then you get a certificate from government that you are a registered IP agent. Any further question? So I will continue. So what I was saying ki for design, it is a very basic thing which every company do, but patent is a very costly affair. It requires a lot of skill, lot of knowledge, and most of the big company they put a lot of money on R&D. So while doing R&D, they develop n number of different process or product, and they are not sure about which one will click. So they keep doing trial. They have a different product which they uh, sell to their fixed customer. They take feedback and then they finally launch in the market. But for all this R&D, they keep filing IPR because they know once it is out, it is very difficult for them to, protect. And especially in patent, it is exactly opposite the trademark. Patent is first in first. So suppose you have developed any product or any process, you have to file the IP for that particular product and process immediately with the government. If you don't file, you have just developed and your competitor come to know about that product and he go and file the patent for that particular thing, then he will get the registration. Because across the world, if anything is developed and you think can be patentable, you have to go and file with the government authority. If you don't file, you cannot claim the rights. In trademark, even if you don't file, you are continuously selling the same brand name, and after 10 years you realize that you want to protect this brand, and you come to know that this brand is registered by someone last year only, and he is using that brand after you. So you can cancel his registration, you can file for the trademark, and you can get the registration. But in case of design and patent, this is just opposite. The someone who filed first will get the rights. It's first in first basis. Any further question? Is it clear to everyone? So now I would like to cover the most important part is valuation. Why the IP valuation is very important for business. You must have seen there are two types of business. One is very organized and one is unorganized business. And in unorganized, you will see thousands of people are selling same product, but they don't have any visibility. For example, uh, atta, which is a very common commodity for Indians. Every house you will find flour, different type flour, bajra, rava, makka, or jwar, gehu. So these type of roti we use in our day-to-day life. And some people use particular brand, Ashirwad Atta or any well-known brand from ITC or any big company. So these are the brand why we use, because it has, we know it belongs to a very reputed company. The quality is good. It comes with the packaging. It can be easily sourced from anywhere in the market. You can buy online, but at the same time, you go to different shop. You go to big market like Vashi, where you find all these item in bulk, but you don't find any brand there. They will sell you loose. They will say just put your any utensil or any bag, and they will just put it in that without any brand. So you go with the just with the price, and you want to save money. So these are unorganized player, and ITC and other big companies, they are organized player. So when we do valuation, the most important part for us is whether the company is filing all the trademark, all the packaging, all the design, whatever they are using, if they have innovative product or process, are they are filing all these patent? If they file based on their sales, based on their number of years in business and the growth pattern, we do the valuation for this particular product. Just one second. Now again, valuation depend on product to product, industry to industry, and geographical area wise also. Some client, they are only selling in that particular city or state. Some people are selling in multiple state, maybe 4 state, 5 state, and their audience are fixed or their customers are fixed. But some of the client, like a big company, Hindustan Unilever, ITC, Britannia, they are selling all across India, and they are not selling all across India, they are selling worldwide, and they have taken protection in overseas market also. They are selling in Asia, they are selling in Middle East, they are selling in Europe, they are selling in North America. So they have a greater sale, they have a greater audience, they have multiple registration, and they have a proven track record. So they get a better valuation, and because they have all the registration already in place, they get a more valuation for that particular brands and other registration. But in case of unorganized player, even though their sales are 50 crore, 100 crore, how you will give the valuation to them? I am selling 100 crore rupees of atta, but I don't have any brand, and my profit is 20 crore, for example, and it is growing every year 5-10%. My sales are increasing. But if I go to any investor and I ask them, see, this is my business and I am selling and I can grow every year 10%. I need an investment and I want to set up a plant. The first thing they will ask me, how people will recollect your brand name, how they will know this is the brand and this is the very quality product, because I don't have any recollect value for them. So for unorganized, if I was supposed to be on 20 crore, my valuation should be 200, 300 crore. It will come down to 50 crore or 100 crore. Nobody is going to give me the fair valuation. It will be at least 1/5 of what was my actual valuation, or maybe 1/10 of my actual valuation. But at the same time, if a company is doing with all these registration, they have a recollect value in the market, their audience know their all the product, and they have a growth trajectory for their all the product, they get sometime not only 20 times, they get 40, 50 or 70 times valuation compared to their competitor. The reason is because their product cannot be easily copied, or they have some advantage over other competitor. Their products are very unique and the tastes are different. I got a one question. What is the annual fees to be paid by trademark attorney, patent attorney too? So, see, when you have a license from the trademark office, normally we don't pay any fees for the this license and all. Once you are registered, it is for lifetime. You can continue using this code. There is no such fees. But if you participate in any government event or any such forum, then you have to pay fees to the government office. Otherwise, there is no fees.
So now this for trademark, is it a separate valuation? Is there a valuation is inbuilt? Say now Tata Motors. My doubt is for trademark valuation, do I have to do separate IPR valuation or it is a part of inbuilt in my business projections? Say example, Tata
No, it is a
Motors.
separate. It is separate. Yeah, I got your point. It's
Yeah.
separate. For example, I tell you, for example, Tata Group. Now when they do valuation, of course, they have a better product compared to their competitor. So they get a first valuation on their product, and then when they say it is they are selling under Tata name, and they have a proven track record, and they are doing business since last 7 decades, they get a better valuation in terms of their product and overall comparison with the competitor. Suppose for any other car manufacturer, if it is 15x of their profit, Tata it will be 20 or 25x.
Mr. Sandeep, can you complete your points like valuation, whatever you want to cover? Questions, we'll take it up in the end.
Yeah, sure. So coming back to valuation, as I already explained how we protect trademark, copyright, and patent. Now think of any business who have all this registration, all the protection, and when they increase their sales, as a valuation expert, if the sales is from 5 crore to 10 crore, so automatically they have done their business 2x. And if they have all this registration, and if their profit, the profit of the company, you can easily do the valuation of the business based on the profit plus goodwill of the business, because they have a recollect value, they have identity in the market, and the customer identify their product. So the valuation become easier. Now it's a very tricky question. How do you do the valuation? It depends on industry to industry, product to product, and then the company. Some of the company like Tata, Reliance, or Birla, they have maybe 30 or 40 different group of companies which they are using for their different product and services. So when they sell this product, they get a better valuation because they are well known worldwide. But if for a small company or a startup, or the company who has started operation in last 5-10 years, they need to do a lot of hard work. They have to first do all this registration, get this certificate, increase their sales, increase their visibility in the market, do a lot of customer survey, and get feedback from the customer. And then when you do valuation, their valuation will be much more higher than what they were doing previously. So for any business, thinking of any valuation without this IPR is very, very difficult. I don't think any company can get a fair valuation unless and until they have a trademark, copyright, and patent registration. That is why your face value is IPR. If you want to get a greater value in business and for unlocking your business from investor, then you should have all this registration. The more registration you have, the more valuation you will get, in short, from anyone. You go to any investor, they will first ask, why should I invest in your business? How my money will be protected? Why I will be assured that this particular business will not be copied by someone, or there will be no competition. So then these IPR you can highlight in your projection. They have taken all this registration, they don't have a competition. These are the protected IP from the government of India or from various other international government, and they are selling, and every year this is the sort of growth they will get from them. Any particular question on this valuation part for IP?
Sir, I am Raghu. I have a question. What are the factors to be considered for valuing what are the IPR rights, and how to assign the value? There should be something, correct? Otherwise, simply we will not be able to quantify it actually. As on today, IPPA and everybody asks, okay, what are the reasons? What are the assumptions? How you can validate it? These are the questions they are asked.
So Raghu, what happened? No, first of all, there are industry norm. Every industry have a different valuation norms, correct? Because some industry require heavy capitalization. You should have a factory, you should have a bigger land, then different department, different process. There may be 3-4 different manufacturing is done, then the final product is developed. So the valuation is different. For some product, the manufacturing is very easy. It's just one process. They do packaging and then they sell. So it depend on first of all on the type of industry, then the number of players in the market. In some of the cases, there are only 4 or 3 players in the market. In some cases, there are hundreds of players in the market. So the product is easily available in the market. So the different valuation is applied. Then it depends on what scale they are selling, whether they are selling in only in their hometown, that particular town, whether they are selling within the state or they are selling all over India, all over world. And then it depends on what sort of IP they have got. They have got IP only for India, they got IP for all over world, or they have multiple IPR registration. Then the valuation will change, depend on this parameter. And of course, some company, they charge very heavy margin. The reason is because they don't have a competition and they have certain advantage over their customer. They have certain IP or their product give you better result, or they are in short, you can say if you are eating that product, it give you more energy, or if you are using their car, they are giving you more mileage, or they consume less maintenance. So the certain parameter we have to consider before we come to any valuation. It's a very tricky thing. You can't have any standard parameter for all this. It will depend on industry to industry and on the business scale as well. And then it comes down to all the IP, what they are getting. Then of course, if you tell me for one particular business, then I can give you a live example for that. I hope I am able to satisfy Ravi. Am I audible?
Yes, sir. You are audible.
So I think I have covered most of the thing, as I have not shown any presentation, because I always believe what is there in your mind, you should speak out. If you have certain fixed slides and all, then it become like a education slot. I don't want to be educator. I wanted everyone to participate, ask question, and then understand how the IP work for the business. And it is a very tricky, valuation is again a very tricky subject. It all depend on business to business and industry to industry, and what scale you are selling your product. If it's very unique and you can encash for next 2 year, 3 year, then in first 2-3 year you get very high profit, and then you sell to someone who can again encash for next 5 year. So it all about how quickly you reaches the audience or your customer. If you can't reach your customer in first 3 year, then you are not getting fair value of your product and your IP and your business as well.
So Sandeep ji, Sanjay here. Okay. When we are doing valuation assignments, what is the average life that we should say? So somebody has patented a particular product, correct? And we need to write that off. And the income tax and the Companies Act have their individual guidelines. And now you are suggesting that there is 10 years and 60 years, correct? In case of patents. So is that the life that we should take for writing off and say that this is valid that during that period? How do we kind of arrive at that?
Very good question, Sanjay. Very good question. For example, you are doing a valuation for pharma company. Now they have a 30 patent. Okay.
Correct.
Now 30 patent have a different time span. Some of
Correct.
the may be having 1 year left, 5 year left, or 10 year left. So what
Correct.
you do, you go to that product sale, this particular medicine, how much they are selling in a year, and what is the profit in the for that particular medicine and vaccine.
Mhm.
So they are selling 50 crore for one particular product.
Okay.
The margin is 5 crore.
Mhm.
And their lifespan is only 2 years left. So you will
Mhm.
get different valuation for that product, correct? Because after 2 years, anybody can manufacture that product.
Correct. It will come out of patent or whatever it is. Correct.
Yeah. So
Mhm.
then we have to see how much time is left. Is there any competition which can come up after 1 year, 2 year, or 5 year? And whether the profit can be decreased, because even the government keep a cap. Like especially during COVID, they told
Correct.
for first 3 years, you
Mhm.
sell at this price. After 3 years, you can't sell at this price because other player will come.
Yeah.
So like for Poonawala, the guy who was manufacturing the vaccine. So
Correct. COVID vaccine. Yeah.
COVID vaccine. So they exported to more than 100 countries. They got a lot of money from the international market. Even Indian government has given a lot of, support to them for their product development. And
Mhm.
they have been assigned patent on a priority basis because it was clinically, everything was proven. They have done some trial, and a lot of people came out of COVID because of those vaccine. This is
Yes.
how you satisfy, investor or the government. So you need a lot of this thing uh, on paper to convince someone. So it is very important the time frame and the sales and then geographical area where you can sell.
Mhm.
This will determine your valuation.
So, I mean, more from our valuers' perspective, and maybe others can also answer that. So, when we take projections from the client and we say that they are going to be 5 times, 10 times, and then 20 times in the next 3 years, 4 years, 5 years, thereafter we take a perpetual growth. So,
Correct.
perpetual growth at that point of time should be really pared down and then brought back to like, okay, the patent will not be there, then there is no protection, correct? As far as we are selling.
Sanjay, what happened now? Like typically some company who are into patent, no, like they have a
Hmm.
multiple patent for
Mhm.
their for new development. So what there is one more criteria. Like I have 10 patented product.
Mhm.
I know some of the product will expire in 5 years. So you
Correct.
say, ki, sir, I can't give you this valuation because your patent is expiring. So
Correct. Correct.
then I can say my another 10 product is in pipeline which will get patent.
So it's a work in progress, correct? That you are
Yes,
saying,
work
correct?
in progress. So for
Mhm.
pharma company, why they get a greater valuation? Because they have 30 product which is patented, but at the
Mhm.
same time another 30, 40 products are going on for patent registration. So they
True.
will
Then we have to see that how strong the R&D department of that particular
correct.
entity is, and if that is not strong, then it has a lower valuation as compared to another company which has got a very strong R&D.
Of course, correct. So for example, like Pidilite industry, they have got some very amazing trademark and patent,
Mhm.
and there is no such competition for them at a India level, or I would say at international level, because their product quality, their product positioning, the brand registration itself, heavy quick, like everything is related to the use of the product. People remember so easily. Now, if you go to any shop or anywhere, what you say, if you want Fevikwel or Fevikwik, you don't remember any other brand. Do you remember any other brand?
No, we just call Fevicol or Feviquick. Yeah, that's what we
So
ask for.
this is how they create in customer mind ki when you need this product, you should recollect our brand. So you get greater value and you are continuously developing new product. So all these question can be answered ki okay sir, our 5 products are expiring after 3 years, but we are developing another 10 products. So we should get more valuation and our sales will increase. Everything comes down to sale and visibility in the market. How you will be visible in the market.
True. Thank you for answering that.
Any other question before we wind up? Because I think we are already 9:20.
Sir, I have a small question. So we talk about the expiring life of a trademark or a patent. So so assume that the remaining.
Pardon, I didn't get you. Expiry means after expiry you are asking? Hello. It was not very clear. Shilpa, could you?
I think,
Since it is expiring.
Can you repeat the question? I could not hear you properly actually.
Yeah. So yeah. Can you hear me now?
Yeah, I can hear you now. Yeah, Sumit.
Yeah. So my question is about that suppose there is a. Can you hear me, please?
Yeah, I can hear you. Please go ahead.
Yeah. So yes, but the company is confident that they will get it renewed and it will continue for long, maybe next 15-20 years or maybe more. So will it affect the valuation, or should as a valuer we consider that long life in valuing the product?
Of course, because see, in trademark, if the customer is selling the product, he is going to renew. If my business is doing well and I am getting more business, I'm going to renew after 10 years. But if my product doesn't click and if I'm not able to do sell, then I might discontinue that product because I'm not getting any brand brand recognition in the market. I will come up with some other name or other style and font. Whereas in case of copyright and patent, if your product, you are continuously developing new product with the same existing product. So any innovation or any changes you do with the existing product, you will file a new patent or new innovation, and then you will get a right for that. So you bound to get do registration, and you will keep doing a renewal for that.
Thank you, sir.
Any more question?
Excuse me, unless there's an acquisition of the company or just the brand, the profits already reflect the brand value which we have generated. Then when we do valuations for regular purposes like ESOP or financial reporting, the value of IPR is not generally included. Is what I'm thinking, is this correct? Only for a buy-sell transaction, we should be considering the value of IPR.
So Vannaji, depend on industry to industry. In some like food business, for example, now Pepsi has a beverages, they have a Lay's chip, and they have certain other product as well. So how you come to valuation? Because you know the sales figure, how much Pepsi as a beverages they are selling. Then they have other beverages with different brand name under Pepsi umbrella. Then they have less chips. Other than chips, they have other product. So you get all the sales. You know how they have protected their IP, and based on their product, you can calculate the valuation for each and every product. And then you can give parent company the goodwill based on their sales and number of year in business with experience. Now how they have grown from last 30 years. If they are growing every year, then they are continuously doing innovation with their beverages, with their product, with their customer, like something new is coming every year. Then based on all these sales and product, you give them valuation. The valuation can be given to one particular product, or it can be given to company combined.
Okay,
It depends on case to case. Yeah.
Thank
Like for example, for an IT company. Now IT company, it all depend on what sort of skills employee they have. IT company normally they are just giving a service to the customer. So it depends how much they are charging to the customer and at what price they are keeping employee on their payroll. The more margin they have, they will get a better valuation. Because here IP, they will have a IP only on certain problem solving program or whatever you say in typical software language, programming, coding and all. So the more they charge to the customer and at a better price they get the employee, that will be their valuation. The margin, the more margin, the more valuation.
Thank you.
Anything else? Anybody have any question? So I think Shilpa ji is good to go. We are 9:27 now.
Yes. On behalf of Bangalore Valuers Association, I request Mr. Naveen Singhal to convey a vote of thanks to our esteemed speaker.
Sandeep ji, it had been excellent session. Normally we talk about numbers, figures, and less about, the concepts behind that or the underlying business. You had spoken a lot about underlying trademark and related stuff quite a bit, even including the process, which a few members were very much keen to learn about those things, clear their doubts. And yes, like I'm sure participants like me would have been a little more expectations on the valuation side. But given that the subject is very complex and it's not easy, unlike DCF, which is relatively easier, it's not that easy to value any trademark or process, patent, etc. Overall, it had been very informative. A bit different from what we normally go through these sessions, and I'm sure all the participants enjoyed and learned from the session. Thanks a lot.
Yeah, so Naveen, I would like to thank Bangalore Valuer Association for inviting me for this wonderful webinar. I completely agree with you. You wanted to focus more on valuation part, but before we come to valuation, it is very important to understand what is IPR, what sort of IPR registration you can avail, then how you get it registration and how it differ from industry to industry, because every industry have a different valuation once you have IPR. So I wanted to first educate them about registration process and how it is creating impact on the business. And when it comes to valuation, again, it is a very tricky subject. Every valuation every valuer have a different opinion on valuation. For example, one of the recent example is Zomato. When the Zomato valuation comes, so we have to go by the vote of majority. If we have a certain parameter which is considered for valuation, based on that we do the valuation, and that is how I explained in short, because I know it takes lot of knowledge, lot of number of webinar to come to conclusion on valuation. So I won't want to take it further, because already we are closing on time 9:30. So maybe next time I can throw more light on this, and anybody who wish to connect with me, they can connect with me, and I am ready to help them more in detail. Thank you everyone for listening me today.
Thanks a lot.
Thank you,
Thanks a lot.
Shilpa ji.
Thank you.
Thank you, sir. Thank you very much, sir.
Thank you.
Sir, on behalf of BDA, we shall be courier this memento to your address. Thank you so much for accepting our last minute invite. And thank you,
My
Mr.
pleasure.
Ravindra, for organizing the physical venue and approaching today's speaker.
Thank you.
Happy weekend.
Have a good day. Bye.
Yes. Happy weekend for everyone. Vijay, you can stop the recording.
Sure.
You can end the session.